7, Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Miller. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I? I need 2 copies of it. Actually, 3.
Your sign.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposed order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant. All right. All right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are, and you have your attorney here, and if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So, you've been subpoenaed in this case to appear before and give testimony in this particular matter, and the state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you've taken the fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So if they ask me a question that implicate me, then...
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you'll tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him.
That's
So
fine.
I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. I will formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what. Why don't you step outside and talk to Mr. Melnick? Come on up, Mr. Copeland. All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right. What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir, go ahead and stand outside, please, if you wouldn't mind. We'll call you in just a minute. All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Good morning, Your Honor. Good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it, but if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983. Also Waldrop, which is Waldrip, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening. I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin. And then Waldrop versus Head says that work product doctrine gives way to the accused's constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They had investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside of that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue first. The first issue of the notes. Okay. Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind unless someone else does, but oral statements must be reduced to writing if they're Brady by the prosecutor.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is the one statement they've turned over already.
And Your Honor, furthermore, in addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Produced as Brady.
If there was, we would have reduced it and sent it over.
All right. Okay. All right. Let's talk about prior convictions. Where's Mr. Melnick? Can you have him come back, please? All right, Mr. Melnick, I wanted you to be here for the this part of the conversation in regards to your client, because these are prior convictions, okay? All right.
Your Honor, Mr. Copeland has a total of 11 convictions, Your Honor, prior convictions. However, based on 24-6-609, we believe that only 4 of them will be able to be discussed during the pendency of this case. The state has not received, and if any defense counsel can correct me, any notice that they wanted to use any convictions greater than 10 years old. And so I wanted to put on the record the convictions that are greater than 10 years old. Again, I did not see any notice that any defense counsel intended to use these, so we can
or the state's intended to use any of them.
Or the state's intentions to use any of them, so that we could have argument on those. So the convictions that I believe should not come in are as follows. 09 SC 82479, which was a September 1st, 2009 conviction.
4.
That one was for theft by taking.
Okay.
Enter an auto and other charges. Oh, well, you know, did he plead to that? Okay. I just want to make sure that he didn't plead to. You know, in all candor, Your Honor, I believe he did plead to giving false info. So for the 09 case, he did plead to giving false information. So they would be able to use that for the limited portion of the fact that he did plead to giving false information.
Yes, that part would be.
That part would be.
Would be admitted.
The next case we have, Your Honor, is 10 SC 87662. And he pled in 2010, but he ended up pleading to a misdemeanor. He pled to misdemeanor theft by receiving. The next is 10 SC 96.
10 SC 96.
938.
Okay.
And that plea was taken on March 7th, 2011. And the charge was aggravated assault and possession of a firearm during the commission of a felony. And then the next one is 12 SC 110195. He pled to this in August of 2013. And he pled to entering auto, several counts, misdemeanor criminal trespass, misdemeanor obstruction, misdemeanor theft by taking. And then on that same day, he also pled to 12 SC 113315. He pled to that on August 13, 2013. And there he pled to terroristic threats, aggravated assault, and battery. Then, Your Honor, he also had another case, which was Law&Crime, which was 12 SC 113001. And another case, which was Law&Crime 13 SC. Oh, excuse me, this was the re-indictment of that 12 SC case. So the number was 13 SC 120161.
What kind of cases were those, madam?
Those were, it was a possession of MDMA and possession of marijuana less than an ounce. And the 13 SC was a re-indictment.
All right.
And so we believe the admissible convictions, and I can put that on the record, Your Honor, would be 15 SC 136794, in which he pled to that in December of 2018. And the charge was theft by receiving stolen property. The next is 20 SC 176851. And he pled on January 25th, 2022.
I'm sorry, Ms. Hill, can you repeat that last number?
Sure. The indictment number or the date?
Indictment number.
20 SC 176851. You're welcome. And he pled to possession of a vehicle with an altered VIN and misdemeanor obstruction of law enforcement officer. Next is 20 SC 176912. And he pled on January 26, 2022. And he pled to possession of a controlled substance, Schedule 1 or 2, with the intent to distribute. And then last is 22 SC 182134, which he pled to on June 29, 2023.
One more time, what was that last number? I'm sorry.
22 SC
2SC.
182134. And he pled to possession of a firearm by a convicted felon. And that was on June 29, 2023. And you're right, there's also a federal indictment. I do not, but he pled to that federal indictment in 2015. And so that indictment would be right. I'll get you the federal indictment number.
Have you shown these, the non-qualifying and qualifying convictions to defense counsel?
I have not.
All right. Can you let them take a look at it?
Oh, they have. Oh, yeah, we did provide.
We do have, well, we did work as well, but we have a disagreement about what's qualified and what's not qualified.
Okay, what do you have a disagreement as to what,
Well,
which matter?
okay, thank you, Your Honor. First of all, we are looking through the court's records. Okay, Mr. Steele says he has it. We did file a motion of intent to impeach with convictions over 10 years old, so we're going to have to address that. But specifically, two of the convictions that the state says are over 10 years old, I disagree with, and that's because the statute reads from my understanding of the statute, and I think the plain reading of the statute, the clock is from the last incarceration.
Is it either or?
Well, it's the one
How's
that's
the statute
the
read?
furthest in time. The 10 years has to elapse from the last incarceration. When that comes into play is when probation is revoked. When there's a split sentence, and then probation is revoked. And I can get you the cases. But, Your Honor, 12 SC 110195, as well as 12 SC 113315, we would agree that the plea was entered over 10 years ago. However, on the court's records, the probation was revoked on 2/21/15. He was in custody at the time, so he's been incarcerated on those charges. The purpose of the statute is that the person has to maintain a history of lawful behavior to reestablish that they are not essentially a convicted felon. And
Which statute are you talking about? Just so I can pull it up. Which one are you talking about?
I don't have the numbers. It's the impeachment by prior conviction. 609B? 609B. So, Your Honor, the statute says, or release from confinement, whichever is the later date, is what I was referring to in the statute, the plain language of the statute.
Hang tight, sir.
Small.